Hello, everyone. I am Alisa Hopkins, and I am filling in today for Steve Holden on today's webinar. This episode is being filmed live at 11 a.m. Eastern, 8 a.m. Pacific time on Thursday, September 17th, 2020. As just a quick reminder, as you all know, COVID litigation is rapidly changing. We have, new reports and rulings coming out every day. So the thoughts, recommendations, and advice from Holden Litigation in today's webinar are our opinions as of today, September 17th, 2020, and of course are always subject to change with the changing times. If you have any questions during the webinar today, feel free to type it in the Q&A box you will see at the bottom of the screen. And we will try to answer that if we can during live on this webinar. If not, we will be sure to respond via email to you and give you a complete answer in that regard. With that being said, I would like to quickly turn it over to our Holden Institute page for a quick update on some matters. Okay, so just a few things to talk about that I think are very interesting. Obviously, with the height of the pandemic, a lot of employers were adjusting and accommodating their employees to telework, work from home type situations. The EEOC has recently come out and said that as the virus becomes less of a threat, that employers are not automatically required to give disabled employees continued accommodations in regard to telework, which is very interesting. And potentially related, maybe not, you have seen a massive spike in COVID-19 related employment suits. These claims include kind of what we discussed in previous webinars that we anticipated that we would see in this regard with retaliation claims, breach of contract, wrongful termination, disability bias, and workplace safety. As of today's date, there's approximately 600 of these cases in litigation across the country that have been filed. About 70 of those are, in fact, class action lawsuits in federal court. Turning to a medical side of things, research suggests, it has come out that there could be some serious long-term damage to a patient's blood vessels from those who contract COVID-19. That's a very interesting fact that we're learning every day. So kind of ending on a positive note with our COVID-19 Holden Institute litigation page, we are seeing, in fact, a downward slope, a decrease in cases this week, about a 2.8% decrease. And you kind of see the sliding scale here. It is, in fact, going down, and we hope that it continues to do so. So with that being said, I would like to introduce my co-panelist today, Miss Kristen Lawhorn. How are you doing, Kristen?
I'm doing very well, Lisa. How are you?
Great. Kristen is a tenure lawyer and graduate from SMU Dedman School of Law. She is the managing partner of Holden Litigation's Dallas office, and she is also a two-time Super Lawyers Rising Star in Texas. So we are very lucky to have Kristen here today.
I'm very happy to be here today, Alisa, and I'd like to give a little bit of information about you, my lovely co-host for the day. Alisa Hopkins is a 7-year attorney. She has her MBA, and she was the editor of her law review in law school. Alisa is also the head of Holden Litigation's research and writing practice, and she is an amazing writer, and she is our resident COVID-19 litigation expert. Alisa, it is so good to be here with you today.
Thank you, Kristen. And so today's episode is on all aspects of updates for COVID-19 litigation. There have been several updates since our last webinar. And so why don't you take us away and kind of give us an update on those things?
Well, Lisa, there's been a lot going on. You know, it's been approximately 6 months since the global COVID-19 pandemic began. And in that time, the world of litigation as we know it has changed. You know, this morning I was thinking today marks the 6-month anniversary of working from home. So there's just a lot going on. And as you mentioned, there are some updates and some of the things that initially started around March and April as the cases of COVID started to become more pronounced. One of the subject matters of a prior webinar was class action suits. And one of the cases that we addressed was Ward versus American Airlines case. And as a refresher, that case was filed by an Arizona resident in the Northern District of Texas. And he was seeking to represent a nationwide class of American airline ticket purchasers who allegedly did not receive refunds. He argued that typically, if the flight is canceled, the ticket purchaser is entitled to a refund. But because of COVID, American Airlines was not issuing refunds. They were giving ticket purchasers the opportunity to either rebook or giving them a travel voucher. And several of the ticket purchasers were like, no, we're not going to have this. We're in the middle of a global pandemic. A lot of us are facing economic hardships. We don't want a travel voucher. We don't want to rebook. We want our money. So there has been an update since our last webinar. On August 13th, American Airlines asked a judge to throw the case out. One of the first arguments that the American airline attorneys made was that 2 of the 3 plaintiffs who had proposed the class action actually had agreed to an arbitration via a clause in their ticket when they purchased it from Hotwire and Expedia. So they're like, you actually don't have standing to bring this suit, you need to arbitrate. And then they also said that American has a conditions of carriage provision for passengers. And that basically states that if the passenger cancels the ticket, they're not entitled to be compensated with a refund. They can take the voucher or they can rebook. And again, the last argument in response to American was, hey, it's a pandemic, we had no option, our safety was being compromised. So right now, that motion to dismiss has not been heard. And here at Holden Litigation, we definitely are watching that one to see what happens.
Very interesting, Kristen. American Airlines has been all over the news lately in terms of COVID-19 litigation. Specifically, late last month in August, it came out that American Airlines announced if it did not receive another bailout from the federal government, that they were planning to furlough approximately 19,000 employees by the end of September. And, at this point, it has not happened. And President Trump has actually discussed and contemplated taking, an executive order to prohibit the furloughing from the airline industry at this point. So that is going to be a very interesting area to watch moving forward to see how that plays out.
Yeah, everything is just so sad. I know I'm here in Dallas, Texas, where Southwest Airlines is based. And this past weekend, I had read an article where Southwest CEO had basically said, if things don't change and people don't start flying and we don't, get some type of assistance from the government, we just can't go on. So that's scary. And, I love flying with Southwest. So I do hope that in general, the airline industry as a whole does recover from this.
Yes, this was something actually that we predicted in earlier webinars, that this type of situation would occur. The airline industry already received one major bailout of billions of dollars. And we had discussed, is that going to be enough? And we said, likely we're going to see this continue to happen, that there's going to be at least threats or actual furloughings and firings of mass layoffs of employees. Will the federal government step in again? Likely something in that effect will happen.
Well, that's good to know that, there is some help out there. We can all look forward to that. And Alisa, as you know, there's been hundreds, if not thousands of lawsuits that have been filed against insurers that are seeking reimbursement for COVID-19 related business losses. And these suits are typically filed under the commercial property insurance policies. I know that you're kind of an expert in general over COVID-19 litigation, but specifically with regard to business interruption. So what are you seeing? How many changes have you seen since our last webinar dedicated to that topic?
Right. So, I believe it was our first webinar we did. Actually, I talked in detail about business interruption claims. It was very early on in the process, so we had not seen many filed at that point. And I discussed some major areas that are going to be major struggles for these insureds to be able to pursue in court. And we are actually now at this point, the update is we're seeing that come to fruition actually. So one of the major areas that I discussed was going to be a problem for insureds trying to collect business interruption coverage from their insurance companies was the aspect that there was no physical property damage, which is a requirement in order to receive benefits from that coverage. So what we are seeing right now, we have had several major rulings in different states that greatly have impacted how these types of cases, if they can or cannot proceed. What we're seeing right now is Michigan, New York, Washington, D.C., and actually in Texas, courts have ruled, in fact, that these types of business interruption claims related to shutdowns from COVID-19 do not constitute physical property damage, and they cannot continue. So these rulings were for the insurance company. We have seen one in the alternative, and that right now is out of Missouri, which the judge did in fact allow the case to continue and did not dismiss it. So depending on, like we discussed, depending on what state you're in, it's really going to determine if you can in fact recover anything from the shutdown if you have a small business.
Yes, and Alisa, you had mentioned Texas. In August, there were actually rulings in 2 lawsuits that originated in Texas over business income losses related to the COVID-19 pandemic related shutdowns. And those both were in favor of the insurance companies. And one of them, a federal judge in Texas, had dismissed an independent insurance agency from a lawsuit that was brought by a Dallas restaurant group that sought reimbursement for business income losses stemming from the civil authority enforced shutdown. So in that case, the restaurant group had added the insurance agency and the insurance agent to a suit as additional defendants. They were actually suing Cincinnati Insurance Company and then went ahead and decided to bring the agent and the insurance agency into the suit as well. And it was over the fact that they had been denied their claim for reimbursement due to these business losses that were, due to a government forced shutdown for them. So the restaurant group claimed that they had over $1 million in business losses across the 3 restaurants that they owned due to the government mandated closures. And they're upset because the policy claim it was denied by Cincinnati. So they filed this lawsuit and they asserted that the insurance agent and the insurance agency misrepresented the group's commercial property all risk policy would cover the losses that were brought on by the pandemic. So what ended up happening is the insurance agency and insurance agent went ahead and filed a plea for dismissal. And they basically said, you know what, the insurance group has not shown, can't show, will never be able to show that it suffered a result, suffered any loss or any breach as a result of the perceived breach. And they also said that they were not responsible for any negligent misrepresentation, and that the plaintiff actually never identified in their pleading how exactly there was a misrepresentation. So that case was heard by U.S. District Judge Sidney Fitzwater, and he agreed with the insurance company. And he said that there had not been a misrepresentation of the policy. So that was definitely a win for the insurance industry. And then in August, we also had another case that had the same type of fact pattern with a barbershop in San Antonio. It was a group of barbershops. And they're like, because of the government mandated shutdowns, we have not been able to go to work. We have not been able to earn incomes, put food on our tables. We are seeking coverage through our commercial insurance policy because of the business interruption. And in that case, again, which involves State Farm as the carrier, the judge ruled that there had not necessarily been any type of breach, and State Farm had actually argued that that specific policy specifically excluded the loss caused by enforcement of an ordinance, a law, a virus, or consequential losses. So this was a little different than the first case we addressed, because in this one with the barbershops, you actually have language in that suit that excluded anything related to a shutdown or a virus. So in your research, have you seen similar cases like this? And for those companies, specifically small business owners who are having claims that are being denied, is there any type of recourse for them to seek some type of financial assistance through these hard times?
So this is actually, I think, a very common issue that has been coming up. I know a lot of my insurance insurance company clients, I have actually been, doing coverage opinions and evaluating the language of their policies to kind of help determine this. So, you mentioned all risk policies that people have been bringing forth, but, that doesn't necessarily mean all inclusive. There are virus exclusions, like you mentioned, written in, things of that nature. In terms of small businesses that, whenever the court determines that they do not have a valid claim for business interruption coverage due to exclusions, due to not meeting the criteria, unfortunately, there really isn't much recourse. The only other real alternative we have seen was, President Trump signed into effect the payment protection plan, which did help a lot of small businesses pay their bills and pay their employees. There might be another wave of that. I know it's in Congress right now. There's kind of a stalemate at this point. We're going to have to watch that and see how it progresses. But if excluded under the policy and there's no recourse for that, unfortunately, there is not much other alternatives.
Wow, that's very unfortunate. We've seen so many companies, businesses, specifically smaller businesses, that have really been impacted by COVID-19, and a lot of them want to rebuild, but there's not a lot of resources. If your claim is denied, there's not a lot of resources out there necessarily for you to start the process of rebounding, especially, I guess, right now when you're in the midst of a global pandemic, where those resources sometimes are going to people who just need to keep the lights on sometimes. So Alisa, we've kind of addressed so far some of the topics that we covered during our prior COVID webinars, but you and I had discussed, as we prepared for this, that there are also some interesting cases coming up. There's a lot of things that, maybe 6 months ago when the pandemic first started, we really hadn't seen these issues, and now we are, and we kind of anticipate seeing some, future ones. And in the recent weeks, there have been several school districts around the country that have returned to school. You've had teachers, students, administrators return to school, whether it be via face-to-face learning, a hybrid of face-to-face or virtual, or just completely virtual. And many districts in Texas, from my experience, have actually delayed the opening of schools. Some flat out just decided to delay school to start after Labor Day, and once Labor Day occurred, they'd come back and then do face-to-face. Some decided they'd do the first 3 to 6 weeks virtually and then make a decision on face-to-face. There's just a lot going on. But there were several districts, including locally in the Frisco ISD, that returned to school within the first 2 weeks of August for face-to-face learning. And when students initially started going to school, there was no requirement that the districts report cases of COVID upwards to the state of Texas. The only rule was that if a student, staff, or teacher, had been exposed or actually had been diagnosed, the school would have to tell all the students and their parents. But there was no obligation to report up. However, things have changed. Effective on September 8th, the state now requires all districts to report weekly the number of COVID cases. This is being done to publicly disseminate the information. We're trying to identify in Texas where the clusters are, because clearly if there's a cluster, you want to figure out what is causing there to be an influx in cases, and you want to do anything you can to alleviate the number of cases and to perhaps put additional protocols in place to make sure that your constituents are, doing well and safe and not really being exposed. So now that the school districts have to report to the state, this information is published, so anyone has access to it, and it's also available to the media. And that was kind of interesting to me, that before, when the school districts didn't have to report to the state, I thought it was a little odd that they didn't even have to report it to the media. So, if you have friends and cousins and you kind of have some type of socially distanced interaction with them, you wouldn't necessarily be aware unless they told you that they were at a school where there had potentially been a cluster, or just a classroom where somebody had been exposed. So I think that in general, the Texas Education Agency really has worked hard and decided that we do need to report the cases because there is a benefit. Is there anything like that going on in Oklahoma that you're aware of?
Yes, actually, I think this is an issue that has been occurring across the country. It's very school system specific in Oklahoma about if they have gone back, if they are completely virtual. There's been talks about, half the week virtual, half in classroom, doing things like pods, which is segregating students into different areas of the school, things of that nature. Actually, in Oklahoma, is something very interesting that we have seen. There is an all virtual school system referred to as Epic Charter Schools here in Oklahoma. And it has actually seen record high enrollment for this school year compared to any other year. And so a lot of parents have chosen to actually remove their children from the public school systems in Oklahoma and enroll them in this all virtual program. And it has been such a demand that the Epic Charter Schools has actually announced that they need massive amounts of new teachers, and there have been teachers leaving the public school system to go work for Epic in that regard, which is very interesting. We've also seen some issues arising in this regard in different states. There have been some teachers who are refusing to go back. You see in California that their teachers union has made a list of demands that they are requiring in order to go back into schools. This could pose a lot of issues in terms of lawsuits, actually. You've already seen some states who have not gone back to the schools but are virtual, that some of the parents are arguing that it is in fact against the state constitution, which a lot of the constitutions they're citing to state that the state is required to give in-person public schooling to taxpayers. And so they're citing that, saying it's unconstitutional and threatening to sue over it if they do not return to in-classroom settings. And I think that this is an issue, depending on how this pandemic goes. Hopefully we're going to see that curve continue to flatten like we did this week. But if it does not, and they're pulling out students from schools, this could be a real issue that we are seeing in terms of litigation from parents.
Lisa, it's absolutely an issue here in Texas and Cameron County. Cameron County is one of the hot spots for COVID cases in Texas. As of 3 weeks ago, I recall that they were listed as number 8 in the state of Texas as having the most amount of cases. And because of that, they decided to postpone in-person school until after September 28th. So there's really not a definitive date for a return to school. Typically, like I stated earlier, we go back in Texas maybe like the second, third week of August. So for it to be postponed by like a month and a half, like that's serious business, right? But what ended up happening after Cameron County, put out this order that says we're not opening for a month and a half later, you had 2 attorneys from 2 religious schools that said, hold up, that's not going to happen. That is unlawful. It is unconstitutional and it infringes upon our religious freedoms. So they threatened to sue Cameron County because of this. And they said, we will come in guns blazing because you're not going to infringe upon our rights. So in response to that, Cameron County Judge Eddie Trevino Jr., he told the attorneys, you know what, you have completely misconstrued our county's order. This is not an attack on religious freedoms. He goes, this is not a political or a religious issue. This is an issue that is with regard to health and safety. We're trying to protect our students, our teachers, and their families. And in his opinion, he expressed that he really didn't understand why these 2 schools had an issue. Like, we're trying to keep you safe. Like, keep politics, keep your religion out of it. Just hold off, and we're gonna keep you safe. You can come back to school later. But those schools were just unrelenting. And eventually what happened is Cameron County allowed those 2 schools to go ahead and resume face-to-face learning. The remainder of the public school districts in Cameron County have not gone back to school yet. There's actually, the numbers of cases are increasing. And as of a few days ago, within the county clerk's office, there had actually been a few cases reported of COVID. So that September 28th deadline or date to return, that's something that we're watching, and that might change. But it's very interesting, like you said, that people just feel like all of their rights have been infringed upon, whether it's wearing a mask, not being able to do face-to-face learning. It's just a lot. There are considerations that need to be made that we had never thought about just 8 months ago. So it's just a little odd. And I think we're going to see more and more people that just kind of use the court system to handle these disagreements. But that one was handled without litigation, although there was a major threat that it would that litigation would be initiated. You'd mentioned earlier, Alisa, that there are teacher unions that are just refusing to return to school. Well, in Arizona, there is a school district that has made some news because as of August 13th, 43 teachers resigned. And this is in the Queen Creek School District. And they're basically like, you know what, we are not returning to in-person learning. The district has not met the COVID-19 safety benchmarks. We are not compromising our health. We don't want our students' health to be compromised. We're not compromising our families' health. But in response, the district wasn't so understanding. They basically were saying, you know what, when you resign, you breached your contract. Because for people that don't know, teachers typically have year-to-year contracts that are renewed or not renewed, or you have an opportunity to decline and not accept the contract. So the school district was basically saying, when you resigned, you ended up breaching a contract. So we're going to fine you. So the teachers, clearly they're in a very odd position, a situation that none of us would want to be in, because they have to make the decision, do we go ahead and do face-to-face learning, although we don't feel safe and we do not feel like the COVID-19 protocols are properly being adhered to? Do we go back to that to make sure that we're able to pay our bills and take care of our families? Or do we indeed compromise our health? But for most of the teachers, they decided that their health and well-being was the most important thing. And the school district went forward with their threat. They actually fined the teachers. And researching, I looked, and some of these teachers have been fined up to $2,000. And, a lot of them are, up in arms, and they're just saying, you know what, like, I have diabetes, I have high blood pressure, I have some other underlying pre-existing condition that just makes COVID a big time threat to me, more than the average person. And now you are actually taking me out of the classroom, period. Like, now, I have to figure out how I'm going to pay for my bills. And a lot of the teachers that were interviewed for this article that was written, they had very good point. They were saying, but for COVID, I would have always gone back to the classroom. I dedicated my entire life to teaching students, to enriching their lives. And now I've been put in a situation where the school district is basically saying, I don't care enough about you to put the proper precautions into place. And if you have a problem, so what? So, I mean, I think that this is not an issue that is exclusive to Arizona. It's not exclusive to Texas. I'm pretty sure you're seeing this not just in the United States, but probably globally.
Yeah, absolutely. I think that California, like I say, I think that's one of the basic examples about you're actually seeing the teachers union almost do a strike with a list of demands. I know that locally here in Oklahoma, where I'm at, you have seen some teachers refuse to come back, some have quit, kind of like you discussed. It is an issue, like I said, if we have another spike, some people are saying we might, hopefully it continues to flatten, but I think that this is an issue that we are going to continue to see, and it's going to become an issue across the country. And like I said, there might be several lawsuits stemming from it.
And Alisa, I know we hadn't really talked about this earlier, but, aside from like the school districts going after the teachers for breach of contract, are there any other claims that they could potentially bring against the teachers?
Any claims they could bring against the teachers for not returning to the classroom?
Yes.
So the main thing that I am seeing right now, and I touched on it earlier, is an aspect from the parents claiming that, virtual learning no classroom learning is against typically their state constitution, what their requirements for public schooling availability for taxpayers. And so you are starting to see a real kind of almost outcry from parents, students who are threatening to sue, saying that what they're doing is unconstitutional. So the state can absolutely, and the school system, take the fall for, potentially teachers refusing to come back or demanding completely virtual learning, that sort of thing. So that, I think, is the area that we need to be watching for.
Absolutely. And Alisa, in the news lately, we've seen a lot about a potential national mask mandate. What are your thoughts about that and the potential legal ramifications to that?
So this has taken a little bit of traction. I know, I believe from some statements Joe Biden made last month when he discussed the potential, if he was elected, he would think that he would want to require a mask mandate on a federal level, at least through the end of the year. He has since walked that back from what I have seen, but the likelihood that a federal mask mandate would happen, I think, is slim to none. It is unconstitutional, and I think that across the board, legal experts have there's almost a consensus that it is in fact unconstitutional. So I do not think that we will see on any type of federal level a mask mandate.
That's very interesting. I think that I've seen a lot of people who are concerned about it. There's some people who definitely would welcome a federal mask mandate, and then others are like, what? That's one more right you're infringing upon. Something just kind of going back to the school stuff that's not necessarily litigation related, but potentially could be, is, with all of us being at home, or a majority of us still working from home at this time, and children also doing virtual learning, it's a lot for parents who are at home with their children to do their jobs, and then to also have children running around in the background. Have you seen any type of cases, I guess specifically related to employment law, where there have been maybe employees who have said that, my employer is not accommodating, to the situation, because of COVID, things are different. Have you seen any of that?
Yes, and I touched on a little bit in the Holden litigation at the beginning of the episode. Under the Americans with Disabilities Act, you've seen some disabled employees trying to bring claims of that nature. I think that one of the biggest examples of employees wanting not to come into work, but their employer forcing them to, obviously has been with some of the meat distribution plants. When you see the massive outbreaks of COVID that occurred there, you see a class action lawsuit that's actually been brought forward against the employer in that regard by the employees, because they did not want to come in. They said their health was at risk. They were forced to, and as a result, this happened. In terms of accommodations, kind of like I hit on, the EEOC just came out and has indicated that as the threat of the virus lessens, employers are not automatically required to continue the special accommodations for disabled employees in regards to teleworking, the work from home aspect, that sort of thing. So it's going to be very interesting to see, if there are lawsuits stemming from that, and how, the EEOC handles that. And if they do a hard, bright line, line in the sand regarding now, the threat has gone down to this extent, no more of that accommodation, or if they kind of, backtrack a little bit on that, that's going to be an area to watch.
I completely agree with that. I have had so many friends contact me throughout the pandemic about returning to work. There was one in particular who's just she didn't have any pre-existing issues or anything like that made her extra concerned, but she has a small child, and she was like, I can do my job from home. I don't feel like I should have to go to the office and be potentially exposed and bring it back to my child. That was her main concern. So I think that you just have a lot of people that are, have specific issues to them and their values, and what they want for them and their families. And I think I've also seen some employers locally, at least with friends, that have kind of bent over backwards to make those accommodations. And it's not because they're afraid of litigation or anything, but just on a human-to-human factor, have been very cognizant of the fact that we are in very trying times. And if your employee feels safe and your employee is happy, they typically will continue to do a great job for you.
Absolutely, absolutely. And with that being said, I don't have anything else. Do you, Kristen?
I don't, Alisa. Like I just think that, we here at Holden, we are always looking at what's going on litigation wise, and you are our COVID-19 expert. So I'm always coming to you and asking you what can we expect? So I think that you have done such an amazing job of definitely letting us know what we can look forward to.
Well, thank you. Since we have a couple minutes left, I saw a couple Q&As came in. So
Awesome.
I was wanting to get to that real quick. And let me see here. Let me pick one out here. So this one says it's specifically for me. This one says, you discussed a federal mandate. Can employers still require employees to wear masks at work? Okay, so the question is, can employers still require their employees to wear masks? We did talk about, the aspect of a federal mandate, which is different. The EEOC at this time still allows for employers to require specific precautionary, PPE type measures for employees re-entering the workplace. Masks are still allowed under EEOC guidelines that employers can require employees. Obviously, you're going to get back into the aspect of employees with disabilities, and they need to accommodate, of course. So, a standard mandate for employees, there are exceptions, obviously, in that regard, for special accommodations regarding disability, that sort of thing. Let's find another one here. I might give this one to you, Kristen. It says, working out of Dallas, I've seen a lot of small businesses in downtown closing. Is there any type of recourse for these businesses?
Lisa, like I have actually witnessed that. Like I frequently, our office for Holden Litigation in Dallas is located downtown Dallas. And every time I drive downtown, I see a new business that is closed. And it's very sad because you have some people who have literally spent their whole lives saving to follow their dreams and open up their business. And the matter of months, they have seen those dreams crushed. And, it goes back to what you talked about earlier. There are programs that definitely can help. If you file an insurance claim for business interruption and it has been denied, there are all sorts of programs that you can apply for to get some type of assistance, whether it be federal, through the bank that you branch with, or I've seen some programs where banks have had COVID relief funds set up to kind of help small businesses. So those are some of the ways that you can, try to get some assistance. But again, it's a completely unfortunate time for so many of us. And it's very sad to see these businesses that I have frequented, shut their doors. And for a lot of them, it is probably for good.
Yeah, unfortunately so. I mean, we did talk about, the aspect of the payment protection program, that sort of thing. We might see another round of that. We'll find out. It's currently idling in Congress, it looks like, and hopefully there can be some resolution that we can help these businesses out. So, well, I want to thank everyone for tuning in today. If we didn't get to your question, I think I see a couple other ones we weren't able to get to. We ran out of time. We will definitely respond to you and post it on the website. If you have any other questions, feel free to contact us. And I want to thank Kristen for being here today.
Thank you, Alisa.
Yes, and so we will see all of you next time on our next episode. Thank you.